Hello, my name is Scott Sturgis. I'm a trustee with the Ohio Jury Management Association. With me today is Judge Reeve Kelsey. Judge Kelsey is also a trustee of the Ohio Jury Management Association. Judge Kelsey and I were at the Ohio State Bar Association studio to record this message about jury service. Judge Kelsey presides over the Wood County Common Pleas Court in Bowling Green, Ohio. Judge Kelsey will discuss the Batson case and other case law relating to the racial and gender makeup of juries. First, Judge, tell us about your background.
I've been a judge for 18 years now. Again, as you mentioned, General Division in the Wood County Court of Common Pleas. Before that, I was 4 years as an Assistant Attorney General with Attorney General Betty Montgomery, and in private practice prior to that.
What is a Batson challenge exactly?
Well, the constitutional principle is that a black criminal defendant is denied the equal protection of the laws when that black defendant is on trial before a jury from which members of his race have been purposely excluded. While that sounds great in principle, it was really very unworkable in practice. That was until the 1986 case of Kentucky versus Batson came along.
Can you tell us what change the Batson case made?
Well, let me review with you briefly the jury selection process. You start off with a big panel of 30 to 40 prospective jurors. After they're questioned by the judge and by the attorneys for both sides, then jurors are eliminated for cause. That's where it is determined that the juror cannot be fair and impartial in this particular case. Then the attorneys have what are called peremptory challenges, challenges for which the parties do not have to indicate any reason whatsoever. The Batson rule is applicable to the peremptory challenge phase. For example, if there is a black criminal defendant and the state exercises a peremptory challenge against a black juror, the defendant or the defendant's lawyer may then exercise what's called a Batson challenge. The defendant must first show that the prosecutor used the peremptory challenge to remove a prospective juror because of the juror's race. That's fairly easy if there's a black defendant and a black juror is eliminated. The burden then shifts to the state to come forward with a race-neutral explanation for challenging that black juror. That neutral explanation does not have to rise to the level of a challenge for a cause. Then the court must determine whether or not there has been purposeful discrimination.
So then the peremptory challenges are limited?
Yes. Peremptory challenges, as the Supreme Court has said, has very old credentials in the common law. And this common law practice does have to yield in the face of potential racial discrimination.
Well, what sort of racially neutral reasons have the courts found acceptable?
Well, a lot of the Ohio cases illustrate the following. A juror who appears to be a very shy and reserved individual, more of a follower than a leader, not an independent thinker. Well, that's a good reason for excluding that person. A juror who had a tendency to interrupt was deemed to be a bully and inappropriate for a jury. A juror who seemed disinterested, falling asleep as if he had something else he would rather be doing. And then another good example is a juror who seemed to have a fairly laissez-faire attitude toward illegal drugs.
Was there a recent Batson case before the United States Supreme Court?
Yes, in May of 2016, there was the case of Foster versus Chapman. In that case, Timothy Foster was accused of murdering Queen Madge White in 1986, and he was tried and convicted in 1987. After all of the for-cause challenges were exercised, there were a total of 41 prospective jurors remaining, of which 4 were black. The state exercised peremptory challenges to remove all 4 black jurors. The defendant invoked Batson challenges. The state offered racially neutral explanations that the trial judge accepted. Many, many years later, Foster's lawyers used the Georgia Open Records Act to obtain the prosecutor's trial notes. and they revealed some rather startling facts. On one sheet, the blacks were all highlighted in bright green and identified as being black. And another prosecutor wrote down, if it comes to having to pick one of the black jurors, this one might be okay. There was another document titled Definite No's, and at the top of that list were all of the prospective black jurors. The Georgia courts then denied Foster's habeas relief based upon a revival of his Batson challenges after these documents came to light. That case then went to the United States Supreme Court, which conducted an exhaustive examination of the jury selection process at the trial many decades previously. In addition to highlighting of the black juror rosters, the court noted that many of the racially neutral reasons that were offered at the trial for challenging the black jurors were equally applicable to many of the white jurors who were not challenged.
Is Batson only applicable to racially motivated bias in jury selection?
No, there is a statement in Foster versus Chapman to the effect that the Constitution forbids striking even a single prospective juror for any discriminatory process. That's a rather open-ended statement. In Ohio, Batson challenges are applicable for gender discrimination also. There is a Ninth Circuit federal case which holds that a juror's sexual orientation could be grounds for invoking the Batson process.
Judge Kelsey, where can we find more information about the Batson case?
The outline of the talk that we've just had together is posted on the Ohio Jury Management Association website. That outline will have specific case citations that can lead a viewer to the actual cases and further authority for what we've just talked about. So hopefully that'll be of some assistance to any viewer who wants to dig in a little deeper.
Thank you. Thank you, Judge Kelsey, for your insights on racial and gender makeup of juries. And thank you to the Ohio State Bar Association for hosting us.